say a little bit about sales. I think the ethical issues about marketing and giving correct information are pretty much the same for sales and advertising. I think there's also a strong moral presumption against deception in sales because of the harm it is likely to cause potential buyers. Such deception is likely to harm buyers by causing them to have false beliefs about the nature of the products in question and causing them to make different purchasing decisions than they would have made if they hadn't been deceived. And it's not above and beyond the call of duty morally for salespersons to refrain from lying deception, even if in some cases they can make more money. They could make more money by resorting to deception. So the legitimate pursuit of your own self-interest or the interests of your employer are constrained by rules against lying and deception. It is morally permissible to promote your interests or your employer's interests, but you have to abide by certain rules in pursuing your interests or the interests of your employer. We might ask, could there be any exceptions to what I've said here? Could there be a plausible justification for deception in advertising? What if the deception will have great benefits for the advertiser? Could a company justify deceptive advertising on the grounds that the company itself and its stakeholders will benefit from it? That's the question. I think that's possible, but I think that such cases would be very rare. In any given case, it's unlikely that the benefits that a company derives from deception will outweigh the harms to other people. Consider this case. Suppose deception provides very great benefits to a corporation, its employees, and its shareholders. Suppose that a company is on the verge of bankruptcy. Lots of people will be harmed if it goes bankrupt, and it's able to stay in business only if it resorts to deceptive sales tactics. I think very rarely in such cases would that provide adequate moral justification for deception in advertising. If a corporation needs to deceive the public about the nature of its goods or services in order to stay in business, its very existence is of dubious value to society. Perhaps the resources it uses could be put to better use in some other way. And I would stress here, in the ordinary course of things, any benefit to the advertiser or the company that practices deception is likely to be counterbalanced by harm to its competitors and harm to the employees, shareholders of the other companies. And of course, as we clearly know, deception in advertising clearly harms consumers, and then there's a general harm to society. There is an important element of trust in society that is harmed or eroded by deception. It's important that people be able to rely on and trust the claims of advertising and business, and the deceptive practices harm all those things. And another thing we should, if someone tries to justify deceptive advertising, that results in a transaction that isn't mutually beneficial. And usually there is then at least an alternative of a mutually beneficial transaction where the consumers buy from some other seller without being deceived, and they're benefited in that way. Consider this, though. What if a company has been harmed and put at a disadvantage because of the deceptive ads of its competitors? So what if a company will lose market share and perhaps become bankrupt unless it runs deceptive ads? It's been harmed by the deception of others. Now, here I can only speak for the United States. In the United States, a business in that position that's been harmed by the deception of competitors can sue for damages. So at least in America, given our laws, that would never really be a justification for deceptive advertising. Here's another case. Just consider this. This is now sales. Suppose the salesperson badly needs money, and the salesperson might try to rationalize deception by saying, I need the money more than my rich clients, and the deceiving my wealthy client won't harm him very much, but the deception will benefit me. I need the money, so it's justified. Now, what do we say about those cases? I think there's a systematic inefficiency of that kind of deception. Suppose that I'm a salesperson, I deceive a customer and make $1,000 sale. And so the customer loses $1,000. But the salesman gets only a small commission of the a small percentage of the $1,000 as commission for the sale. Maybe there still could be cases in which the salesperson needs the much smaller amount of money more than the consumer needs the money spent. So here's an example. Students often raise this as a case. Salespeople have quotas. They have to sell a certain amount. Suppose you're likely to lose your job unless you meet your monthly sales quota. You very badly need the money. And you can meet your quota only by deceiving your customer. Those, I think, really are very difficult cases. I'm not sure I can say that deception is wrong in every such case, but I would want to claim such cases are very rare. I think in practice, very, very rare. And let's consider one other possible justification for deception in sales or advertising, a paternalistic justification. Suppose you say, sometimes consumers won't make rational decisions on the basis of correct information, and in those cases it's permissible to deceive people for their own good. So here's an example. I'm selling automobile tires, and my tires are very expensive. So I exaggerate the risk of driving on inexpensive, cheap automobile tires to manipulate you into purchasing more expensive, higher quality tires than you intended to buy. And I might say, well, I deceived you, but I'm still justified. You're really better off with you're safer and better off with my expensive tires. Now, very conveniently for me, this deception also benefits me because I earn more of a commission on the sale. I think it's pretty presumptuous to say, for any salesperson to say that he knows better than a well-informed customer what's in the customer's interests. You know, what's really best for the customer depends on all kinds of facts about the customer, including the customer's bank account and economic situation that salespeople rarely know about. If the more expensive tires really are better for the customer, then I should be able to persuade them of that without resorting to deception. I suppose there could be some cases in which this kind of paternalistic deception would help others. However, I think those are very rare cases, and I think there's still very good reason to think that this is a very harmful and unjustifiable practice that's seldom really helpful to customers. In part, it's a very bad and harmful practice because it tempts the seller to a kind of self-deception. I deceive myself into thinking that I'm helping you by deceiving you when I'm just really earning money for myself, or as we say in English, lining my own pocket. And in any such case, I think it's fair to say that the salesperson has a distorted view about the merits of whatever he or she is selling. I'm hardly an unbiased or impartial judge of the merits of my products. So if a salesperson claims that what he's selling is safer than the competing product, that might be true, but the person's judgment is suspect and likely to be mistaken. Okay. Am I going too slowly? What? Okay, good. Okay, we're fine then, I think. Very briefly talk about some U.S. laws concerning deception in advertising and sales. I think there's a need for laws and regulations prohibiting deception in advertising, deception in sales. If such laws don't exist, business practices sometimes resemble the law of the jungle, and honest businesses can be put at a severe competitive disadvantage by the dishonest practices of their competitors. I want to very briefly explain a few important American laws about selling and advertising, and I think our laws in America have certain strengths and weaknesses, and it would be useful for all of you to think about the pros and cons of the American laws in connection with Peru's laws and regulations. U.S. law voids all sales and contracts if they involve deception by the seller. So this means that sales are not valid or legally enforceable if the seller makes false or deceptive statements about what he or she is selling. So if, for example, if I sell you a car, a used car, and I deceive you about the condition the car is in the eyes of the American law, it's not a valid sale. You're entitled to get your money back. The law says we don't recognize that as a valid sale. In the U.S., the laws concerning deceptive advertising are administered by the U.S. Federal Trade Commission, prohibits deceptive advertising, and in judging whether an ad is deceptive or not, it looks to see whether the ads convey false claims about the products. So essentially the definition in the U.S. law is that a claim is conveyed if consumers believe that the ad is making that claim. And then the standard for deception is this. An ad is considered to be deceptive if it conveys false claims to more than 25% of the target audience. So if my ad, if they just survey consumers or sample consumers, and if 25% of them, more of them claim that the ad conveys a certain claim to them and the claim is false, then it's thought to be deceptive. Further, the Trade Commission regards an ad as deceptive only if the deception is likely to influence consumer behavior and purchasing decision. Now, there's an interesting and less well-known feature of our laws. It's the so-called Lanham courts. Lanham courts are special courts in which businesses can sue other businesses if they feel they've been harmed by the deceptive practices of their competitors. And the Lanham courts apply very strict criteria for deceptiveness, so they consider an ad to be deceptive if it deceives more than 15% of the target audience. And I think these are an important feature of our system. They're a significant remedy and deterrent to deceptive advertising. And I'll give you an example here. This is a very recent case. It's still in court. There's a beverage in the U.S. called Palm Wonderful, which is a beverage made from pomegranate and blueberry juice. This juice consists of 85% pomegranate juice and 15% blueberry juice. And they're suing the Coca-Cola company, which sells a competing product called pomegranate blueberry juice. Now, although Coca-Cola markets its so-called pomegranate blueberry juice, 99% of this juice consists of apple and grape juice, which are far cheaper. So it's called pomegranate blueberry juice, but 0.5% of it consists of pomegranate and blueberry juice. So I think very clearly the Coca-Cola company is guilty of deception in that case. You can't, if you call something pomegranate blueberry juice and it's 0.5% of those two juices combined, that's clearly deceptive. These American laws provide important and needed protections to consumers and to other businesses, but they're far from perfect. I think the Federal Trade Commission standards for deception in advertising should be stricter. At present, ads that deceive many people, and it seems to me ads that can cause a great deal of harm, are generally permitted as long as they deceive less than 25% of the target audience. So at least in my opinion, the American law shouldn't permit advertising that deceives so many people, and it really should do more to protect ignorant and unsophisticated consumers. There, I think the law doesn't adequately protect people. All right. I'm going to conclude by talking about the question of withholding information and just the general issue of duties to provide information. Even if advertisers and salespeople refrain from deception, that doesn't ensure that their customers and clients will be well informed or that the exchanges the customers enter into will be beneficial to them. So here's a case in point. You might harm your interests and waste your money in purchasing something from me, not because of my deception, but because of your ignorance or lack of knowledge about what I'm selling you. Even though you may not have been deceived by me, you may not have full or accurate information about what I'm selling. So this then really raises the question of whether salespeople and advertisers have positive duties to provide information to the public. So here's the question. Is it morally permissible for sellers and advertisers to withhold or fail to provide relevant information about the products they sell? Should they provide information about competing products which might be cheaper or better for the client than their own products? Clearly, in many cases, giving all this information, including information about your competitors, oh, by the way, my competitor's product is better than mine and it's cheaper, presumably that information would benefit consumers and customers. So consider professions like law and medicine. Lawyers and physicians have positive duties to provide all relevant information which would be useful to their clients. And their duties to provide information go far beyond simply refraining from lying and deception. But we generally think that it's enough for advertisers and salespeople to refrain from deception. We think, generally, that advertisers don't have the same kinds of obligations that lawyers and physicians do, the obligations to provide information. That's the conventional view, and I think it's basically correct. I'll try to explain why, and then I'll be done. Typically, when professionals work for clients who hire and pay for them, they're obligated to act as fiduciaries for the benefit of their clients. Now, a fiduciary, it's a fancy English word, is someone who is authorized to act for the benefit of someone else. Law and medicine are clear examples of this. A physician is a fiduciary for patients. Law and medicine have codes of ethics that require their members to act for the benefit of clients. In the United States, many other professions, including architecture, financial planning, to name just a few, also have codes of ethics that explicitly require professionals to act for their clients. in the United States, the codes say for these professions also include explicit requirements that members of the profession have to be candid, disclose all information that would be helpful to their clients. And since those codes of ethics are publicly stated, and they're in part designed to encourage the public to trust and rely on the services of members of the professions, members of those professions have a very strict and solemn duty to follow those obligations. So professionals like attorneys, physicians promise to follow their codes of ethics. So I'm almost at the very end. Oh, okay, 2 minutes. I'll be done before then. Thank you. I don't think that advertisers or salespeople have those same kinds of fiduciary obligations to consumers. Advertisers and salespeople don't work for and are not paid by consumers. They work for and are paid by the companies that are trying to sell their products. So they don't have the same kind of contractual fiduciary obligations to act for the benefit of consumers and provide them with all relevant information that might help them. Now, they clearly have duties to refrain from lying and deception, and I think they have limited positive obligations to provide information. I think that's a minimum. But they don't have to provide all the information that would benefit the customer or client. Because, I mean, if you take that seriously, give them everything that might help them, it might involve saying, by the way, my competitor sells this same thing for less, or something like that. I don't think advertisers or salespeople have the obligation to give that kind of information. So, thank you very much.